Good day. Dear students, today we will discuss about patent rights. In the previous session, we have discussed on the topics nature of intellectual property, its classification or types, in which we have seen patents, industrial design, copyrights, geographical indications, trademarks, trade secrets, and rights. So, all those things we have discussed in the previous sessions. Again, we have also put a point on international scenario, and then at the end, we have seen if we want to fill a patent in over 140 countries through a medium that is called as PCT. And also we have seen the advantages and some limitations. In this video, we will see scope of patent rights, licensing and transfer of technology, and then patent information and patent database. So we will start with the scope of patent rights. Now there is a revision, that is Patent Act is Patent Act of 1970. The first Patent Act was introduced in the 19th century. It is level of protection has evolved. And in 1995, the trade-related aspects of intellectual property rights, that is TRIPS, was signed and followed by the Madrid Protocol, which offered the trademark protection. That is in 1995. Trade-related aspects of intellectual property rights. There has been recognition in government circles of the need to protect IPR. To promote innovation and entrepreneurship and strengthen the existing laws, the government created the National Intellectual Property Rights, that is IPR, Intellectual Property Rights Policy, that is National Intellectual Property Rights Policy in 2016. And a slow but steady progress has been made in ensuring the patent protection in India. Stronger patent protection laws have been opposed by some who believe it could harm India's interest. So that's why the stronger patent protections are not employed. It could, for example, increase the cost of life-saving drugs and put them beyond the reach of large segments of the Indian population. Generic drugs, which are relatively inexpensive and accessible, are also produced in large quantities in the Indian pharmaceutical industries. So these are some hurdles. The production of these would be made much more difficult by a stronger IPR regime. Patenting seeds and other products may also threaten the food security if IPR laws are strengthened. So other products may also get threatened if India makes stronger patent protection laws. Again, another problem is lack of awareness among the people or among the inventor and the system. According to a study by Enflow, an international patent analytics and market research company, Enflow is an international patent analytics and market research company. So what it says according to the study that most respondents over 200 educational institutions in South India. It may consist of Tamil Nadu, Kerala, Karnataka, Andhra Pradesh, and Telangana states. That over 200 educational institutions were unaware about the benefits of intellectual property. So that shows the lack of awareness among the researchers, and this is through educational institutions. Means the professors or the researchers who are working in that particular field. So this is one problem, lack of awareness. Another question is, how will intellectual property rights be protected in India in the future? So in order to protect these IPRs and maintain the national interest also, the government must maintain a delicate balance because it is a two-sided coin. As India makes significant strides in science, technology, agriculture and culture, a stronger IPR regime can't be ignored. It is impossible for innovation and creativity to thrive without strong intellectual property protection. It will be impossible for innovators and creative people to reap the rewards of their efforts. So if the stronger protections are not here, then the innovators and creative people will not get the rewards for their efforts. So this is another thing. Now, scientific innovations have been made in India by institutions like CSIR, that is Center for Scientific and Industrial Research. Due to weak IPR protection, they have been unable to commercialize many products. So, due to weak protection, they are unable to commercialize many products. In addition to the public sector, the private sector also stands to benefit from stronger IPR laws. So, not only the government sector or public sector, the private sector is also get benefited if the stronger IPR laws comes. India is one of the world's leading startups after China and UK, according to the report by the Center of American Entrepreneurship. As part of the Forbes list of the world's most innovative companies, 5 Indian companies made the list. So it shows the growth of India in entrepreneurship and startups. Stronger protection for their products and processes will also benefit company like this. So if we employ the stronger protection of IPs, then it will enhance and benefits the companies over here. The future of patents in India will depend on three things. So first one is awareness about the patent and intellectual property right benefits. So awareness about the intellectual property rights and patents. Second is stronger enforcement. And the third one is convincing Indians that national interest will not be compromised. So these three things will take the future of patents in India. Now this is about future scope of patents, scope and future of patents in India. Now we'll talk about the licensing and technology transfer. So we'll see one by one. Technology transfer, it is also known as transfer of technology, TOT, and technology commercialization. So technology transfer and technology commercializations are the processes by which the information or knowledge related to the technological aspects travel within the group. So information or knowledge related to the technological aspects travel within the group or between the organizations or entities. So that is nothing but the technology transfer. So if knowledge of the technological aspects will be shared or is transferred to some other entity or other organizations through some conditions, clauses. So that is nothing but technology transfer. Taking this to the broader scenario, give rise to the international technology transfer in which knowledge travels in between the countries. So it may be transfer of technologies between the group or between the entities, between the organizations, or it is at the international technology transfer is between knowledge sharing, knowledge travel between two countries or between the countries, which is not only limited to the knowledge and information, rather includes skill transfer, methods of manufacturing, physical assets, know-how, and other technical aspects. And henceforth, It helps in further development of that particular nation or nations of the technology and innovation by effectively utilizing the technology transferred and finally incorporating it. So it benefits the transferer or the transferee who employs that technology. So at both the ends, it is beneficial for the further development in the technology and innovations. So in short, it is the process by which information or knowledge related to the technology aspects is transferred. Technology transfer has been used in the movements of technology from the laboratory to industry or from one application to another domain application or taking developing countries into consideration. Technology transfer helps in growing access to technologies which are related to other developed countries and henceforth helps in approaching towards the newer technologies and inventions, that is from developed to developing countries. So it has been used in the movements of technology from the laboratory to industry or from one application to another domain application or taking developing countries into consideration. Technology transfer helps in the growing access to technologies which are related to other developed countries. So the technology transfer may happen between developed countries with the developing countries, and it may be possible that newer technologies and inventions occur. On the other hand, licensing is allowance granted by the patent owner. It is allowance granted by the patent owner to another person or organization for using the patented invention or agreed terms and conditions while the patent owner continues maintaining his ownership. Suppose I have one product which I have patented and some other person or organization wants to use it, and on certain agreed terms and conditions I will allow him to use that particular product, and still I am will be the owner of that particular product of patent, and hereafter becomes the source of income by receiving the predetermined royalties or as per the conditions whatever on which terms agreed terms and conditions are there. So the owner will get the predetermined royalties based on that agreement. So that is nothing but the license. So by combining the concept of technology transfer with the licensing, one can help in taking benefit of technology research that has been done previously, as licensing creates the permissible structure for the transfer of technology to a larger assembly of researchers, engineers, innovators, which help in saving the expenses of conducting the research and cost of maintaining the development activities. So it helps in uh, saving the expenses of conducting the same research and cost of maintaining it if the technology transfer occurs. Technology transfer as with the licensing, development activities or facilities, and hence will help in the further development of the technology which has already been done. So it will help in creating further development. As nowadays in the era of advancement in the technologies, there are many technologies which with the combination of the other technologies is giving birth to the other new advanced technology. So here the licensing do play the important role. So in providing the legal platforms, licensing provides legal platform to utilize the combination of technologies made or discovered by the other persons or the organizations which has been created earlier, and hereafter prevents from wastage of the time and the research cost incurred in developing the earlier invention. So there is a statement by Geoffrey Nicholson, the father of the post-it. What he says, research transforms money into knowledge, So research transforms money into knowledge, whereas transfer technology transfer transforms knowledge into money. And in general, this technology transfer process is given in a nutshell in this picture. That is discovery, then disclosure, then evaluation, then evaluate intellectual property protection, marketing, licensing, and then the product development, and then public use and financial returns. So this is a cycle of technology transfer process. Now there are majorly two types of technology transfers. Our technology transfer is classified into parts. One is technology transfer, and other is horizontal technology transfer. So what do you mean by technology transfer? It refers where transmission of new technologies is done from the generation of new technology. So new transmission of new technologies is done from the generation of new technologies during the research and development programs into the science and technology organizations. For example, for instance, to the application related to the industrial and agriculture sector, or vertical transfer is the technology transfer commencing from basic research to applied research, from applied research to development, followed by development to production. So we can understand this vertical transfer is technology transfer commencing from basic to applied research, applied to development, and development to production. So that is nothing but the vertical technology transfer. And what about the horizontal? It is the movement of well-known technology from one equipped environment to another, from one company to another, or say it refers to the transfer and use of technology used in one place or organization to another place or organization. So it is a well-known technology or existing technology which is already well established, and it is used in other company or other place or another organization. So that is horizontal technology transfer. Now, how it is done generally in developed countries, the route of technology transfer is like this, that is research, then development, design, and then production. This is followed in the developed countries, whereas in the less advanced or developing countries, it is little bit different. That is initial, it starts with the production, then design, development, and then at the end it is research. So generally there are the reverse trends in the developing countries. It is exactly reverse. If you see here, in developed countries, research, development, design, production. Whereas in uh, developing countries, production, design, development, and research. So that is a reverse trend in the developing countries, because the path to be followed depends upon the transfer, absorption, and adoption of existing technologies. Now, one of the innovator, ABB, in 1990, he used to refer to as the architect of the Indonesian aircraft industry, and he states that technology receivers must be prepared to implement manufacturing plans on a step-by-step basis with the ultimate objective of eventually matching the added value percentage obtained by the technology transferring firm. And he refers to such an approach as progressive manufacturing and popularized the slogan begin at the end and end at the beginning. So implying that transferee firm should start with production and move backwards to research. So he has developed this slogan begin at the end and end at the beginning. That implies that transferee firm should start with the production and move backwards to research. And today in era with advent in technology, one could choose any one of the routes of technology transfer, which depends upon how the technology advancement chains of the transferer and transferee are associated. So it depends on the how the transferer and transferee are associated. Accordingly, one can go for research, development, design, production, or production, design, development, research tool. Now we'll see some of the advantages of technology transfer. The advantage related to technology transfer comprises of essential gain to the public who benefits from the manufactured goods that get to the market, and ultimately the availability of the jobs which results from the improvement and sale of the products so formed. So it helps to gain to the public who benefits from manufactured goods that get to the market, and ultimately the availability of the jobs which results from the improvement and sale of the products, and hence it encourages use of technology. So it encourages use of technology develop and benefiting to the society development. So it benefits to the society development which comes from the revenue of the taxpayers and escalating visibility to researchers and allows researchers to generate and earn royalty income. So it also helps to researchers to generate and earn royalty income, and henceforth attaining a financial profits for the government and the employees from the royalty payments for those technology transfers that involve patent licenses. So wherever patent licenses are there, it is gets from it gets benefited by the researchers, innovators, as well as the governments through taxpayers, as well as it creates jobs through sale, manufacturing, and design. So these are some advantages. Then what are the other advantages? Resulting in commercialization of researchers and discoveries made, which was the course of the investment done for the development and being protected by the patent. So initially one has to protect the invention through patent, and then while doing the commercialization one has to incur the cost, and hereafter all the investments done in the course of the development in intellectual property are returned. So that is initial cost only, and these are returned to the public through products made for the public, opportunities of more employment, and revenue in the form of taxes. So all that money can be returned or one can get benefits. Technology transfer strengthens the industry. This is important by identifying new business opportunities which contributes to enhancing the know-how and competitiveness of technology providers. So it strengthens the industry by identifying new opportunities as well as competitiveness among the technology providers, and which ultimately results in broadening the business area and refocusing to the technologies and systems to serve several different fields. And in addition, technology transfer promotes the wider use and awareness of technology and systems. So this is very important. It strengthens the industry through these mediums. It creates new opportunities, new businesses, then it creates competitiveness among the technology providers, and then it broadens that particular area. Similarly, technology transfer brings economic benefits by increasing revenues for both technology donors as well as receivers benefits with new and better products, processes, and services that lead to increased efficiency and effectiveness, greater market share, and increased profits. So it uh, creates economic benefits. Moreover, technology transfer helps in earning rewards also, which is above and beyond the regular salary, which is received through patents, licenses, and other technology transfer awards, which help in benefiting the intellectually and professionally through working collaboratively with their peers in the industrial sector. So it benefits the researchers, employers who works on the research and development, or the innovators who do get the royalties from the licensed patents. Now there are some disadvantages also of technology transfer, and it can be the chances to have financial or commercial risk. As we are all aware that licenses can generate the income, but patent application which are not licensed will not cost money. So if it is not patented, then it will not be benefited for the inventions or the innovators. Even when the transfer program related to technology transfer is successful or in a particular after technology transfer, institutional tensions may arise within the organizations. So this is another point which may be considered, that is institutional tensions may arise within the organizations, which may be between recipient of licensing income and those who know they will never make utilizable inventions. And in most of the cases, discoverer will be frustrated or disappointed because of the income, because the income that they have earned is given to other groups. So this is one problem. Technology transfer activities may put researchers in conflict of interest situations, especially when the transfer involves the creation of the spin-off company. Hence, institutions should be aware of these possible dangers. Again, problem can be because of non-performance of license, and maybe the license has limited chances beyond the license scope unless future enhancements to patent included in initial agreement and unrealistic expectations and demands from the licensor. Now, if we consider the Indian scenario about the technology transfer, it is growing exponentially and played an important role in all around development and growth of the economy in country. And India has opted for a wise mix of original and imported technology, and therefore it plays an important role covered by technology transfer agreement. And developing countries like India generally not follow the usual path for the development with regard to technologies, but use their advantage in the cutting edge technology options which is now available and put the tools to use this modern technology. So use their advantage in the cutting edge technology options. When technology transfer is assumed to get benefits from R&D, which is shared with the developing and underdeveloped countries. So taking this to the point of consideration, national research laboratories is being constructed by Indian government. So national research laboratories has been constructed by Indian government for the purpose of R&D, which is yet to be commenced by the private sectors. So in India, mostly small and medium scale industries or enterprises are growing since the liberalization, which has resulted in growth of the multinational enterprises, which in turn is competing with the international companies, which has enhanced the confidence of India. So small and medium scale industries are growing, and due to which there is a growth of multinational enterprises, and due to which competing these multinational enterprises are competing with the international companies, and that enhances the confidence. Not only confined to the pharmaceuticals, but is broadly categorized in auto, steel, manufacturing, metal industries also. So, or even agricultural, dairy, and other technologies also. Government of India is in the verge of to open technology transfer offices. So it is on the verge of opening the technology transfer offices or universities or institutions which will be funded by central government and will act as mechanism for transferring or exporting the research conducted and its outcome to the desired place. So it will be very beneficial if such technology transfer offices are opened in India. Through some of the Indian institutes have been already commercializing their research and are successful in technology transfer in which they have been licensed as technologies to industry. Moreover, numerous cases of technology transfer are seen in India by various well-known institutions. So, institutions like IITs and NITs, IIMs, they are already employing this uh, technology transfer. Now, after this, last point is patent information and database. So, patent information is the technical and legal information contained in patent documents that are published periodically by patent office. So, these are technical and legal information contained in patent documents that are published periodically by patent office. The phrase patent information refers to both granted patent as well as patent applications. So it does not mean only granted patents, it is applicable to both granted as well as patent applications. So patent documents include not only the content of published patent documents but also bibliographic and other information concerning patents for invention, inventor certificate, utility certificate and utility models. In most countries, a patent document is required to be in a standardized format. And what is that standardized format? We'll see one by one. So it will include front page, and in which it consists of date of filing, priority date, information on the title of the invention, bibliography data, that is the name and address of the applicant and the inventor, and an abstract. And again, in abstract, it should summarize the invention covered by the patent document. The abstract has no legal importance. It is technical summary that is not relevant for and therefore cannot be used to interpret the scope of the protection of the invention by the patent person. So it is a technical summary of that particular patent. Then there is a section written description in which description of an invention should disclose the invention clearly and precisely. So whatever this invention is carried out, it should be clearly and precisely explained in the written description to enable a person skilled in the art to understand and claim the inventions and technical information contained in it. Preferably, it should be illustrated by examples to explain how to work or carry out the invention in the practice so as to enable anyone skilled in the relevant technical field or art to do so likewise without undue experimentation. So it should disclose the invention clearly and precisely to enable the persons skilled in the art or understand the claimed invention. For them, it should be clear and precise description must be given. The next section in the patent documents is claims. So it should define the scope of legal protection, and in patent legislation, interpreting claims is the first step. That is, interpreting the claims is the first step in determining whether the patent is valid and whether the patent has been infringed. So that's why claims is the first step in determining whether it is valid or whether it is infringed. Then next section is drawings, if necessary, or you can say optional. So generally drawings show technical details of the invention in an abstract or summarized manner in a visual way, and they help to explain some information, tool or results set out in the written description. So whatever is written in the written description, they can be visually seen through the drawings. And these are not always necessary part of the patent specification. So it may be possible that in some cases it is not possible to draw, then one can avoid. If the invention is for a process or method of doing something, drawings usually are not required. So if drawings are required, formal rules govern their acceptability. Now these are related to the patent information. Now what are the advantages of this patent information documents? First thing is up to date informations can be seen. That is, in most countries, a patent application is published 18 months after it is filed, and there is therefore always a time lag between invention and publication of the patent. And generally, however, patents are granted well before the patented product is introduced in the market. And As such, publication of patent application, despite the time lag, is invariably the earliest point in time at which the relevant information becomes available to the public. So only once it is patented or granted, then only it is available to the public, and then uh, it gives the up-to-date information about the particular invention. Uniform structure. Patent documents have relatively standardized format, including, just we have seen, abstract, bibliographic information, description, claims, drawings. So these illustrate the invention and full details of the applicant. So such uniform structure makes reading easier. So this uniform structure of the patent information makes the reader or the new inventor easy. Detailed description. As the invention has to be disclosed in a manner that is sufficiently clear and complete and precise for it to be carried out by a person skilled in that particular field. So detailed descriptions are very important. Unique source of information. It is estimated that some 70% of the information disclosed in the patent documents have never been published anywhere else. It is also growing in size every day. To date, some 50 million patent documents have been published worldwide in every technical field, with about 2 million more documents added each year. So that is how this patent the technology is going. So unique source of information. So whatever documents you are writing, descripting or related to the invention, it is estimated that 70% of the information disclosed in patent documents have never been published. So 70% of the documents have never been published. Then it is possible, and at this time it is unique source of information, and that is the advantage. Next advantage is well-organized information. For easier search and retrieval of patent documents, they are classified in accordance with an internationally accepted classification system called International Patent Classification (IPC). So, well-organized information in structured manner or in the standardized format. That is one advantage. Next advantage is quick and easy access. So, patent information may be stored in a variety of information carriers like paper, microfiches, CD-ROM, and online database. Online searching has facilitated quicker, cheaper, and more convenient access to patent information than the convenient manual or CD-ROM based searching method. Then, wide fields of technologies. So, why not all the inventions are patented? For some inventions may be protected by trade secrets rather than by the patents. Invention protected by patents cover virtually every field of technology, from the simplest to the most complex. As such, patents provide information on every sphere of scientific and technology activity. So, wide fields of technology, it will cover wide field of the technology, science and technology activity. Then, one more advantage about the patent information is citation intelligence. Citations on the patent document are information of prior art cited by the examiners or applicants. The examiner cites references which contain relevant prior art to judge the patentability during the patent prosecution. So, similar to the article or public journal paper, one used to cite or give the citations to the earlier work. So, similarly, here the uh, citations on patent document gives an idea about what are the work has been done or what related work has been carried out in earlier by the different patentees or innovators, or it may be possible that examiner cites the references which contain relevant prior art, so to judge the patentability whether to grant or refuse. So these are the advantages: up-to-date information, uniform structure, detailed description, unique source of information, well organized information, quick and easy access, because nowadays everything is available on the web. So earlier it is a problem that either it is available in the libraries or patent office in the form of papers or CD-ROMs. But nowadays, as due to digitization, most of the things are available on the fingertips on the web. So therefore, it is advantage of patent information which can be accessed quickly and easily. Then another advantage is it covers wide fields of the technology, science and technology. And the last advantage is citations intelligence. So it will give an idea about the prior work or the prior inventions which are related to that particular invention can be seen or observed. Now comes the patent database. So till now we have seen patent information. Now the patent database. And one of the most crucial steps in the process of securing patent rights is the patent search. Because to get the patent rights, first you need to do the patent search. And the process for undertaking a patent search has changed extensively over the time. Just now I mentioned that before the age of computers, individuals seeking to search a patent history were forced to look through microfiche and hard copies of field patents, the reports, documents, and that time the process was long and painstaking. But computers dramatically changed this manner in which we research prior patent filings. And now patent applications are generally stored in both private and public databases. Searching for prior patents now happens almost entirely electronically, that is through the internet. So entirely electronically. The companies or governments that manage the patent database develop search algorithms to more effectively search. So to identify if such patent, if someone applies for the patent and if such work or invention is already carried out or not, to find out that such algorithms or patent database are available and one can easily find out and one can effectively search those previous database and then come to one conclusion. This is the beneficial for the evaluators. The choice of patent database highly depends on motive beneath it, or in other words, the type of patent search involved. For example, a prior art search that is for current litigation. You would want to choose a patent database that covers the patent documents of most of the patent offices. Exhaustiveness is going to be the key for you. That is, if you if a topic is related with the materials used in the batteries, then it is specific related to the batteries or materials. And if it is a general topic, then exhaustive search one need to do. And such databases are available freely as well as with subscriptions. And one can, before filing a patent, one can do the exhaustive search in the free or paid patent databases and then can proceed for the patent filing applications. Now, here are some of the list of free patent databases. So one is Google Patents. First is, this is a free patent database. You can see Google Patents. So you can search here Google Patents. Say, and you can ternary lithium battery material. It is granted in 2018. See a different. It is similar to the literature survey or literature review we do for writing an article or publications, and you can easily find out here all the documents related to that, the patent file. Or if you search some other point like smart grid building system, smart grid, yeah, different topology estimator. So here is an abstract and then description, detailed description, then patent citations. This is like a reference section in an article, and the one who have cited this patent, those also given here. Similar documents, then other information like parent applications, priority applications, legal events. So this is a Google patent. Then second one is ESPASnet patent. See here again we get application, inventor, classification, priorities, application, publication, published as, and then the total. Abstract is given, description, detailed descriptions are given. Drawings we have seen. Drawings are given to support the detailed description. Then USPTO Web Patent Database, PQAI, Patent Scope by WIPO. So this is patents, World Intellectual Property Organization's patent scope. You can see a patent scope database, and it provides to international PCT applications and all that. So while before filing a patent, one can go through all these. These are free patent databases. Now there are paid patent databases also like Derwent, PatBase, PatSeer. Try this one, PatBase login. So we need to take the subscription for this. Similarly, other databases also available. PatSeer and website, drug patent, PatSnap. So these are all paid patents, but there are free patent database also available, and one can use these free patent database before filing the patents. And when it comes to patent database, every tool has its own advantages and disadvantages, limitations and functions. So therefore, finding the right database that suits your specific need is important. So while you are doing this search, exhaustive search, you need to identify which database suits more to your invention. However, even after locating the perfect database for yourself, analyzing the vast amount of patent data can be overwhelming and challenging. So it is very challenging because one need to ensure that the invention we are going to file has never been publicly put in the form of articles or in the form of some products. Here are some of the references used to prepare this presentation. I hope you have got an idea about what is patent information database, then scope of patent rights, then what is licensing and what is transfer of technology, and how licensing and transfer of technology benefits the inventor, the organizations, and the countries. And at the last, we have seen about the patent information and what it contains and what is the advantages of patent information, as well as we have seen the free and paid patent databases available. So this ends this patent rights chapter. Thank you. In the next lecture, we will see the point related with the new developments in the intellectual property rights.